All rise. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge J. Simpson.
You may be seated. All right. Right.
Yeah, he's ready.
Back on the record in the case of the People versus Radcliffe. Counsel is present along with the defendant. Mr. Thomas, you may proceed.
Thank you, Your Honor. And Judge, I would just like to address what we were last talking about before you left. And
yes, sir.
You know, it's page 5 with victim D and victim D. And I went back and I've looked at these things. And again, Judge, if the court has any, any concerns regarding my client with that type of contact, the one thing I would remind the court of, one, if it did happen, then I would say, obviously he wasn't under a court order or anything at that point. And so I understand the court's concern, but we would be willing to, have no contact orders, take away, and give up on any electronic devices, no phones, no computers, none of that. And I think that would obviously put to rest any possibility of him. And obviously, if he violated that, he would be right back here in jail. It would not be wise for him to do that. It wouldn't be wise for him to contact that. And honestly, Judge, it would be contrary to what I would advise him to do.
Well,
so
right. And let me make myself clear that I'm not saying that he violated a condition of bond. I'm not saying anything along those lines. I'm saying what troubles the court is that behavior where there are these allegations that are out there, and then behavior to, so I'll put it in the colloquial, just to either cover up or interfere with and or obstruct an investigation. That's what bothers the court. I'm not saying that he should be charged with anything. I'm not saying that. I'm just looking at the behavior of the defendant, because that's what I've got to bank on if he were to be released. And I'm pointing out what at least is alleged, a behavior that is very troublesome for the court.
And does this go to risk to the community, Your Honor, that you're talking
It
about?
certainly goes to risk to the community, and in my experience, also would go to the issue of, can I trust this person to not flee? Because in some way, this can amount to some type of obstruction of justice or some type of interference with an investigation. And do I believe that that person, assuming, and I'm not saying, not trying to necessarily make an accusation, but if somebody were to do that, can I trust that person not to flee the jurisdiction?
And again, Judge, I'm sure you've been doing this a long time. I've been doing this an awful long time myself. I've had, this is not my first bond hearing. I understand the court's concerns, and under the circumstances when you have somebody that's got no prior criminal history whatsoever, you've got somebody that's never lived outside of Michigan per se, other than being in Virginia for Liberty for school for whatever that time period was, that has lived here his entire life. His entire family resides here. He doesn't have a passport. So it's, with the lockdowns that they have today, I mean, it's probably pretty impossible to try to get off, out of the United States without a passport. And obviously going anywhere else in the country, with the computer system, the NCIC and everything else that's out there, it makes it almost impossible for somebody to just disappear and never be found again. It doesn't happen. I mean, I don't think I can think of one case where I've ever seen as an attorney where somebody didn't show back up.
But counsel, it isn't even the issue of will they be found again. It's the issue of will you attempt to try to flee the jurisdiction. I mean, and it's a slight distinction, but there's a distinction in it. So
I'm just saying, Your Honor, with the bullet points that I've already presented to the court, that he's not an alcoholic, he's not a drug abuser, he's had a job his entire life. He's got family and friends here. There's nowhere for him to plea. He's not going to plea. I don't think the court has anything to worry about with the fleeing portion of this. And I don't say that lightly, Your Honor, because I understand the severity of these charges. I get the concerns of the court, and I don't take that lightly. I don't take my position as his attorney lightly in that matter. And so, I drive 2.5 hours to get here every time I come here. I certainly don't want to represent a client that I would think is going to flee the jurisdiction and not do what I'm telling him and directing him to do. I certainly would direct him to make sure that he's in court. He knows what the evidence is at this point, Judge. And I told him, obviously we're here to defend this, and he's here and he wants to defend it. And obviously that is our goal, is to get through these PCCs, get through the preliminary examination, and let the chips fall where they fall when we get through the preliminary examination. And if any charges that still exist after a preliminary examination, then we'll deal with that in circuit court. So obviously, our position as Judge is that he's sitting in jail for 105 days. The evidence in this case just, to charge people with CSAM and not have any CSAM just doesn't make any sense to me. And then to file more charges for the same charges without knowing that you didn't have any CSAM doesn't make any sense to me either. So in light of all that, Your Honor, just the magnitude of these charges that are presented on top of him doesn't mean that, hey, there's more charges I'm going to take, possibly be a flight risk or a danger to the community. He wants to face these charges. He wants to exonerate himself. That's what he wants to do. And so with that being said, Judge, my client is going to appear for these court dates. He's going to appear with me. And again, he's got all these people that are supporting him. He's got the letters that were presented to the court. He's got a place to stay. And we will give up any electronics. We will give up anything the court wants. If you want to put a tether on them, we'll do the tether. We'll put them, no contact orders. Take away all electronics. Anything that the court would make it feel safer for him to be out. He's going to get a job, and he's going to go to work, and he's going to live with his family. He doesn't need to have access to any of that stuff. So the court can put those no contacts, and if he violates, then throw him back in jail and keep him there. I have no problem with that.
Thank you. Ms. Rice.
Thank you, Your Honor. I would indicate to the court that the defendant was arraigned and arrested on or about October 20th, 2024. At that time, Magistrate Fink set the bond at $3 million, no 10% cash or surety. Once the defendant was arraigned, additional victims did come forward. At the time of arraignment, he was charged with 1 count of criminal sexual conduct in the first degree, with 1 listed victim and additional approximately 11 additional counts of child sexually abusive activity and using a computer to commit a crime with different victims than the listed victim for the criminal sexual conduct first degree. When the additional victims came forward, the defendant is now, after the arraignment and the bond being set at $3 million cash or surety, facing 6 additional counts of criminal sexual conduct in the first degree with 2 separate victims. And I state that because the court rule and the statute allow this court to deny pretrial release of a defendant charged with criminal sexual conduct in the first degree if the court finds the proof that the defendant's guilt is evident or the presumption is great, unless the court is presented with clear and convincing evidence that the defendant is neither a flight risk or a danger to the community. And I would submit to you, first and foremost, Your Honor, there was no abuse of discretion in the magistrate setting the bond at $3 million. But if we're going to look at the bond that was set at $3 million, the things that have changed since that bond was set is additional victims have come forward. So it would not be appropriate to reduce the bond. And in fact, the people are requesting that the bond be denied because there's no clear and convincing evidence that the defendant is neither a flight risk nor a danger to the community. This information in the investigation began on or about August 26, 2024, when it was reported to the police department, to MSP. One of one of the victims reported to the defendant's girlfriend at the time the things that the defendant had done to him. When his girlfriend at the time confronted him about that, confronted the defendant, she had a 6-hour longer conversation that night discussing the victim that had come forward. The defendant told her not to believe a word that he said, and he left her house around midnight. He told her that it was best that she not tell anyone that the majority of their conversation was about that victim. And he reminded her that they still had a 2-week break left in their relationship and not to contact him. Another victim came forward, and that's when she broke up with him. After that conversation, on August 30th, 2020.
Excuse me one moment, sir. Counsel, when you want to talk to your client, make sure to push the button on the top.
Yes, sir.
These microphones are very sensitive and I don't want a conversation.
Thank you.
All right, go ahead, Ms. Rice.
On August 30th of 2024, the defendant then called that victim 8 times and told him that he needed to keep his, quote, fucking mouth shut, end quote, because there was no information that he could tell Brianna. And that's referenced in page 8 of the people's motion. So this is information that the defendant, that we have during this investigation. This is how he's acting when he's not been charged, when he's not been arrested and not been arraigned. He is intimidating and threatening the victims. And I would submit to this court that he is a flight risk. During the investigation, on October 21st, 2024, the Michigan State Police interviewed the defendant's parents. He was informed by the defendant's parents that the defendant went to Virginia after news of this broke. He may have stayed with his college friend Phil, whom he knew from Liberty University. His mom thought that she went to stay with her sister Rhonda in Indiana after he left Virginia and gave Rhonda's address. Rhonda dropped off 2 suitcases of Zach's to Frank and Robin. Frank went through the luggage and found a MacBook inside. The trooper took custody of the laptop. Robin and Frank did not know the passwords to any of the devices. The defendant's mom cried during the interview and said that Zach had been leading a double life.
Counsel, I don't want to interrupt you, but I want to make sure that I'm understanding this. In October of 2024, the defendant, after the investigation starts to happen, he leaves the state to go to Virginia.
Correct. Around the time that the news broke, but before he's been arrested or arraigned, he left and went to the state of Virginia.
Okay, so when you say the news broke, when it became public.
I don't know exactly
news.
when they referenced, but I'm presuming sometime in the end of August, beginning of September, when everyone in the community, the church community, and the victims started coming forward and reporting to the police.
Okay, and so he left the state, some thinking that he's in Virginia, others thinking in Indiana. Irrespective of that, for how long a period in time was the defendant not in the state?
I don't know the answer to that. They had just started to take the investigation and interview these victims. And when he was ultimately arrested, when the police arrested him after the conversation where he made admissions to one of the mothers about having these boys send him pictures of themselves masturbating, and he would pay money for them. When he made those admissions that are on tape that will be played at the preliminary exam, he was driving a rental car and had multiple electronics in the rental car that were seized. So that is our evidence, our indication that he is a flight risk. So
and I'm sorry, but the rental, or he was arrested in the state of Michigan.
Correct.
All right.
In
a rental vehicle.
Dundee. In a rental vehicle.
In Monroe County, down in Dundee?
Yes.
All right, go ahead, I'm sorry.
So that is just some of the information that the people believe that the court can consider and show that he has a flight risk. Beyond that, Your Honor, counsel talks about just because of the number of charges that the people bring doesn't affect bond, and I think it does. In this case, the allegations are, and the evidence will show that the defendant abused his position of authority at the church. So it's not, we don't have one victim or two victims, we have multiple victims spanning over a year period of time. So he is a danger to the community, and the people's position is if he were released, he would be contacting these victims, and there's nothing to stop him from contacting. Sure, there's a court order and we can violate his bond if he does it, but the appropriate thing in this case and the multiple counts of criminal sexual conduct in the first degree allow for this court to deny the bond. And that's what we're asking be done. The statute, the jury instruction on criminal sexual conduct in the first degree concludes that to prove this charge is not necessary that there be evidence other than that of the victim, if that testimony proves guilt beyond a reasonable doubt. So the victims of the criminal sexual conduct can come here and testify at preliminary exam. They can testify at trial, and the defendant can be convicted on it. There's not one victim of criminal sexual conduct in the first degree, but there are three. And so I don't believe it was an abuse of discretion to set the bond at $3 million. I do believe, based on the evidence in this case, that he is a danger to the community and moreover, a danger to the victims in these cases. So I don't think it should be reduced. And we're asking that pursuant to the statute and pursuant to the court rule, that it be denied.
Thank you. Response.
Yes, sir. So going back to the arraignment when he was actually given the $3 million bond, obviously the court didn't have access to what we've given the court, which is the doctor's report for one, you know, the letters of support and all these other things that are out there. Two, you know, there was no discovery that had even been conducted at that point. So whoever the attorney was that was arguing on behalf of my client at that time didn't have anything really to hang a hat on to make any kind of argument whatsoever at that time. But some of the things that the prosecutor just said in regard to this investigation in October, she doesn't know what the dates are when he was gone, when he came back. He came back to face the charges. He wasn't arrested somewhere else. He drove back here to face the charges. So he's not a flight risk. If he was a flight risk, he would have stayed where he was at. He obviously came back here to do the right thing, and that was to face the charges. And he cooperated with law enforcement. There is absolutely nothing that the officer in this case wrote in his report to say anything other than, he was cooperative. If he was a flight risk or if he didn't cooperate with at the time, that would have been written in the reports, and it's not. It's not written in the report anywhere that he was uncooperative or anything else. He absolutely came back and faced the music and got arrested, was even in the front seat of his vehicle, handcuffed in the front, from what I recall. Maybe he was in the back, I don't remember. But obviously he came back, to face the charges. So he is not a flight risk. And again, he doesn't have anywhere else to go. As I said to the court already, there are so many different things the court can impose. You can take his driver's license away, you can take electronics away, make no contact order. He is not a flight risk. He's not going anywhere. And again, going back through the answer to,
well, what was he doing in Virginia? And how long was he in Virginia? And did he end up in Indiana? And how long was he in Indiana?
You probably got to drive through Indiana to get to Virginia, I think.
No, being a Maryland Terrapin, you don't have to do that. In fact, you stay as far away from Indiana as you can.
I'm not from here.
So, no. So what was he doing in Virginia?
He just reminded me what he went down there because I think that he had friends that were in Virginia, and he went down there to visit a friend, and he came back. So it's like a vacation that he was on, which is allowable, Judge. I mean, if you're not under.
I'm not saying it's not allowable, but counsel, you're leading this court to believe, and I'm not saying it may just be semantics, but you're saying to me he's only resided in the state of Michigan. I get the whole schooling thing, but that's not true. He resided in the state of Virginia. Then when all of this is at least brewing, from what I understand, and is out in the community, he then takes back off to Virginia and or Indiana for at least some, I don't.
From my understanding, it was only a week, Judge. Only a week. It wasn't even, I don't even think it was a week. Because he was back here, I think he was arrested on the 20th of October was the arrest date. And I think that it was, it was only for a few days, maybe from the 15th of October to the 20th, something like that. Might have been a little longer, but I'm not sure what the dates were, but I know that he drove back on his own accord and came back. So there's nothing that anybody can say to the contrary to that. And, if he drove back here knowing that there was an investigation going on, if he was going to be a flight risk, then why would he drive back here? His intention was to go to Virginia and say, I'm not going to face the consequences. And why didn't he just stay there? He came back to face the charges. So, the flight risk thing doesn't work. And again, Judge, I'm not trying to play semantics on the court whatsoever.
No, I'm not saying that you were trying to play a game with it, but I'm just saying my interpretation, certainly, of what you're telling me gives me a different picture. That may just be how we view the world. That's fine. But prosecutor does bring up a good point, and I don't know what your response to that would be, that at the time he's arraigned, there are a certain number of charges that are pending. The bond of $3 million is set based upon those charges. Additional charges are then filed. His bond remains the same. They don't ask at that point to up the bond. But as it sits before me right now with basically these competing motions, given the charges, and it kind of shifts in terms of one's burden, why wouldn't I grant the prosecutor's motion to deny bond unless I have before me something that is clear and convincing that he is not a flight risk and that he is not a danger to the community? Why wouldn't I?
And I would agree 100% with what you're saying, Your Honor, except for the fact that all the bullet points I've already presented, I don't want to beat a dead horse here, but again, if you look at the answer in her complaint, that she can either admit or deny, for one, the meat and potatoes of my argument in 6, 7, and 8, she doesn't admit or deny any of those. So if you can't deny them outright, then your case must not be that strong if you can't deny it. She obviously doesn't have the proof.
Yeah, but that's not my standard, is it, under the rule? I mean, the charges have been brought, and if I believe that there's a likelihood of conviction, then certainly I can go one way. But on the charges, certainly I could deny bond unless there is clear and convincing evidence that he does not pose a danger to the community and or flight risk.
Right.
And I'm getting, and counsel, and I'll just tell you, I mean, I sit here and I cannot certainly predict the future. That is not my job. But I certainly have to look at a person's behavior to try to assess what is the likelihood that that person will do it. And I'll be honest with you, I'm not getting really satisfactory answers to his whole Virginia connection, to where was he? And you're saying it's a vacation or whatever, but okay. And the contact with individuals and what he's saying to those individuals, knowing this is going to happen. I'm a bit hard pressed to say that that person doesn't pose a danger to the community in terms of what he will do. but I'm more than willing, I mean, I'll stay here as long as I have to. I'm more than willing to hear all of that. But those are things that go to those core issues of, does he pose a flight risk? I understand he has no criminal record, so I don't have that. But when all of this is going on, why does he take off to Virginia? And then these people, maybe this wrong, who are so close to him, they're not really sure where he is. Is he in Virginia? Is he in Indiana? Two suitcases for 5 days? I don't know. But depends, I guess, on how you pack.
I
But
lived with my wife before either.
pardon me? Well, yeah. But that's a problem for the court.
Well, the only thing I can say, Your Honor, to this is this, you know, if the guilt was evident and presumption was great in this case, you know, we would have way more evidence to look at.
But
don't have-
but counsel, here's the thing. As Mr. Reiser is pointing out, if one of these victims gets up and says, this happened to me, and lays out a series of events and a series of facts, then certainly he could be bound over to stand trial. And certainly a jury could convict solely on that. I mean,
You convict on circumstantial evidence. I don't disagree with you, Judge. Circumstantial, you know, I can make an allegation against anybody.
correct. But then counsel, and I get that charges, the number of charges don't matter. But what the court also, in looking at that particular issue, does have to take into account is the people's rendition in their motion. There is this repetitive predatory behavior. Realistically, as our society is under circumstances that are really troublesome because of his position and these young adults. But it's not just one. I mean, there are just these numerous people, like victims, but an odd commonality to what they're saying. And maybe not so odd, but there's certainly a commonality as to what they're saying. That's anything else you want to say as to, under the rule, as to whether or not the court should strongly consider the people's request that I deny bond? Is there anything else you want to say?
Your Honor, I just think that, you know, based on what I've already presented to the court, you know, with the low risk from coming from a doctor in your jurisdiction, that maybe he's even been in front of this court, I don't know. But I mean, obviously she put him as a low risk. I think that should weigh heavily on the court. I think that, you know, his prior record, the fact that he doesn't use drugs or alcohol, that he has his entire family here, that he could get a job, that we're willing to let you take the electronics, no contact order. I think that, you know,
If he got a job, counsel, what would he be doing?
he does music, Your Honor. I mean, he could, you know,
Would he be around people, young people? Or people younger?
not have to be around any young people, and the court could order him not to be around. That wouldn't be a problem. It's not any problem whatsoever. If you want to put him on house arrest, put him on a tether, he's willing to take that as well. You take his driver's license away and make him have to get driver's.
Counsel, I'm aware of what I should or could do.
I'm just saying that, Judge, there's ways that the court could obviously make sure that if he bonded out, that there's not going to be a threat to the community and he's not a flight risk. And I think that we've submitted many letters of people that have known him his entire life, friends and other people. I mean, he's got a whole courtroom of people on this side over here that are here to support him. And, and just the fact that he came back from Virginia and drove back here, which he didn't have to do. If he was going to be a flight risk, why would he do that? He's here. He did not try to stay gone. He came back saying, hey, I got to go back up there and I got to pay this community. And he came back. And that should be the telltale right there, Judge. I think that, weighing these factors into place and going, okay, well, you might be a flight risk. Well, anybody can be a flight risk. Anybody. You could have a spitting on the sidewalk charge and be a flight risk. But I understand because of the type of charges that we're looking at, it's going to be scrutinized much harshly. And again, I think that we presented enough to this court, and getting a doctor to come in and see him in the jail and going through all these different things that we did. And again, this is my first try at a bond with this court. I didn't represent him at the arraignment. This is the first time it's been addressed in almost 105 days. So, this is our first shot at, asking this court to reconsider a $3 million bond. This family doesn't have $3 million to post a cash bond on this type of case, Judge. And, again, it's tantamount to no bond. So, and it's not a
which can be appropriate in cases like this. You keep saying that, counsel, but I mean,
if the evidence is great and the presumption is great, if the guilt is evident, then yes. But again, Judge, you've even said that it's a circumstantial case at this point.
I haven't said that.
Well, I'm saying this.
I did not say that.
I know. I didn't mean to say. I'm saying that it's a circumstantial case at this point. And so, if the evidence was overwhelming at this point, where we had all this stuff that was just coming at us left and right, obviously, I would be in a very different position. If I didn't think I, had to hang up here, I wouldn't be doing this right now. But I've looked through all the evidence. I've seen what they have. And I mean, obviously, my client's innocent until proven guilty in this case, and he has a right to go to trial if he wants to go to trial. And obviously, he has a right to go through the preliminary examination, and we're going to hear from witnesses. But again, putting a $3 million bond on a case where there's not any CSAM and there's 33 counts that involve CSAM, or a lot of them anyway, not all of them, but it's just one of those things that, I think the court should consider that, a reasonable bond in this case, which is guaranteed by our Constitution and the Supreme Court the Court of Appeals of Michigan, the site that I cited to the court earlier, guarantees you a reasonable bond. And if the guilt is not evident and the presumption is not great, then you have to move on to the next prongs, which is whether he's a flight risk or danger to the community. And then even if the court deems that doesn't mean no bond. Obviously you could put a higher bond on him, but again, an unreasonable bond for a guy that's indigent at this point. He doesn't have, his truck got repossessed. He doesn't have a home. He doesn't have anywhere to go. All this stuff is gone to four winds. He doesn't have a phone or anything else. He doesn't have a computer. He doesn't have anything. So he's indigent at this point. His support's coming from outside influences, outside people and whatnot. So he doesn't have two nickels to rub together. So at this point, Judge, what I'm saying is that I think the court should look at all those factors that, it takes to be a flight risk. You got to have money. You got to, people don't pick up hitchhikers anymore. It doesn't work that way. I'm asking the court to consider it. I think that our request for a lower bond is reasonable based on the circumstances.
Anything additional from the people?
I do, Your Honor, I do. It is not disputed that after these allegations started to surface, but before the defendant was arrested, that he left and went to Virginia. Whether he went there for vacation or to dispose of evidence, he left the state of Michigan. When the defendant was arraigned and charged, additional victims came forward. And I'm going to provide the court with an offer of proof of what one of those victims will testify to. And at the conclusion of that, I will ask that his bond be denied.
Go ahead.
The victim was jealous of Zach because Zach was a cool guy of the church. Everybody talked to Zach, and he seemed like he was a safe space for people. The victim got an iPad Touch for Christmas when he was 14 years old, and he got Snapchat in February of 2015. His parents did not want him to be on social media, but he defied them and got a Snapchat account anyways. The victim's handle on Snapchat was this. Zach, the defendant, added the victim on Snapchat, and they talked on Snapchat. Around June 2015, the defendant asked the victim on Snapchat if he had abs, and he asked for a photo of the victim shirtless. The victim sent the photo, and Zach told him to delete the photo from his phone. The victim did this. A few days before the first incident, the defendant asked the victim on Snapchat if he knew what a blowjob was. At that time, the victim kind of knew what it was. The defendant asked the victim if he would ever want one. The defendant offered to go on a drive with the victim and they could listen to music and talk. They hung out alone only on 2 occasions. The first incident was a Saturday night in July of 2015. The victim was 14 years old. He remembers this day because he went to church the next morning. On Snapchat, the defendant asked the victim if he had ever gone out late at night. The victim was bored and wanted to go out. In the middle of the night, the defendant drove to the victim's house. The defendant was driving a smaller sedan. The victim snuck out of the house and he got in the defendant's car. The defendant was in the driver's seat and the victim was in the front passenger seat. The victim remembers where they drove on Calder Court and parked on a street south of Harper Drive, so they were still near the victim's house. The victim was wearing loose shorts and he was a virgin. The defendant put his right hand on the victim's left thigh and began to rub it up and down his leg. The defendant asked the victim about blowjobs. The defendant made it seem like blowjobs were a thing that he did with his friends. He called them bro jobs. The defendant chucked the victim's penis over his short and with his right hand. The defendant used his right hand to pull down the victim's shorts and underwear to his feet. The victim said he froze out of shock because he didn't know what to do. After the defendant pulled his underwear and shorts down, the defendant touched his exposed penis with his right hand. The defendant leaned to his right and put the victim's penis in his mouth in a sucking manner. He sucked on the victim's penis for 3 to 4 minutes. He stopped sucking on the victim's penis when he ejaculated in Zach's mouth. The defendant asked if he was okay and the victim said he did not know. The defendant asked if it felt good. The victim said he felt weird. The defendant told the victim he did not have to do it again, but he wanted to give him a space to feel good. The victim asked if he could go inside. And the defendant was okay with that. So the victim got out of the car and went back to his house. Said he could not sleep that night. The next morning he had to go to church and Zach was there. They did not talk about what happened the night before. His parents didn't know he snuck out. The victim said he was scared because Zach was a bigger guy. The second instance occurred in 2016 when the victim was 15 years old. They were still on Snapchat, and the defendant alluded to engaging in more sexual activity, but the messages did not use the word sex. The victim would confide in the defendant about getting in trouble with his parents. and the defendant picked him up in the middle of the night. He instantly came down to get the victim. In the same sedan as the incident before, the defendant was in the driver's seat, the victim was in the passenger seat. They drove to Oakwood Church's building, currently the Washtenaw Christian Academy. They pulled into the parking lot. The defendant asked the victim if he'd ever given a blowjob. He said he did not. He kept pestering about giving a blowjob, and the victim was hesitant and told the defendant he felt weird. The defendant pulled his own pants down and said that the victim should suck his dick. And the victim said, I don't know if I want to. The victim froze again and the car was silent. A few seconds later, defendant started masturbating while the victim was sitting there. The defendant whispered to him, you should help, and the victim didn't move. The defendant put his right arm around the victim's shoulder and neck. The defendant pulled the victim toward his lap, and he felt like he did not have a choice. The victim sucked the defendant's penis for about 2 minutes. The defendant had his right hand on the back of his neck, and if he tried to sit up, the defendant pulled him back down. This ended when the defendant ejaculated in the victim's mouth. The victim turned to the right, opened the passenger door, and threw up. The defendant asked, why'd you do that? And the victim did not respond. The ride home was silent. He dropped the victim off. The victim did not sleep that night. He had nightmares. He was scared for his life because he thought Zach had a gun. Before this, he said Zach always had a gun on him, but he did not see a gun on this night. His parents didn't know about it. They forced him to go to church. He would see the defendant at church every time. The defendant would tell the victim they shared a cute little secret. In a span of a few months after the second incident, the defendant texted the victim to see if he wanted to meet up, but the victim declined each time. Then the defendant started to ask him for videos of him masturbating. He didn't send any. The defendant in June of 2015 asked the victim if he could ever send a nude photo before. The defendant offered to send the victim a photo of him. The defendant said he would pay him $20 for the photo, so the victim sent the defendant a photo of his penis on Snapchat. The defendant gave him $20 cash for the photo the same night of the July 2015 incident. During the trooper's interview of the victim, he teared up, his body shook, and he took a deep breath and long pauses. He said these events were hard to talk about. We're asking that the bond be denied. That's one victim's testimony that I anticipate you will hear at this preliminary exam.
Of course, we're going to take a brief recess, read over the documents, the letters that you sent, make sure I have that, take a look at it. I will come back and give you 14 minutes.
All right.